So let's start off by looking at explaining, well, what is a letter of indemnity? And letters of indemnity have become increasingly common in the shipping industry as a tool to smooth the logistical process of delivering cargo. Their frequent use reflects how often nowadays cargo is delivered without the surrender of the bill of lading under which the cargo is being carried. To give you an example of the importance of letters of indemnity and the absence of bills of ladings arriving at discharge ports, I've been involved as a shipping lawyer now for over 34 years, and over that time have probably attended hundreds of vessels and interviewed literally hundreds of crew members. And in that 34-year period, and all those crews and vessels that I've met and interviewed on various matters, I have never met a tanker master that has received an original bill of lading. They've always released cargo as against a letter of indemnity. So that just gives you an example of just how important these documents are. And it's a commercial reality which has given rise to many legal and practical risks. And we're going to discuss what those risks are during the course of this webinar. We've talked about the risk of fraud. As a matter of public policy, the English courts will not enforce a letter of indemnity to support a fraud. Therefore, the letter of indemnity will be unenforceable, but there'll also be no club cover and no recourse under the LOI. That means that the beneficiary, the ship owner, often will be 100% liable for their own loss. And that will be the case even if the charter party provides that an LOI is to be given in consideration for certain activity. The court will construe such a clause as merely applying to a lawful activity. And since the person being asked to perform the task has a duty to refuse it, if it's illegal or fraudulent, if they do not refuse and they continue to commit an illegal or fraudulent act, then they do so at their peril. Now, how could a situation like that arise? Well, say charterers request to issue an antedated bill. That's a fraud on the bill of lading holder who rely on the date in the bill of lading, including the date, to decide whether to accept the cargo or not. The most common situation is where a owner is asked to issue a clean bill, even though the carrier and the master is well aware that the bills ought to be claused to reflect the true condition of the cargo. The case that gives birth to this situation is a very well-known one in shipping terms, one to which you will hopefully be familiar, but if you're not, please do go and read it. It's a very important case. And it's Brown Jenkinson and Percy Dalton, 1957, to Lloyd's Report 1.